Hello everyone, my name is Arnold Van Dyke, Director of Tax Services with Tax Audit, where we help individuals and businesses resolve their tax problems. So today we're going to be talking about one of the best weapons that you have against IRS collection action, and that is the collection due process hearing. Except for very, very rare circumstances, the IRS cannot just come out and take property from you. They can't just take money from your bank account or take your vehicle or your home without obviously following law. Even the IRS is bound by the US Constitution, and the US Constitution states in the Fifth Amendment that government cannot take property, a person's property. A person may not be deprived of life, liberty, or property without due process of law. And that's where the due process hearing comes in. So before the IRS can take your process, they do have to give you a right to a hearing. Now, when can you request the collection due process hearing? You can request it either in response to the IRS issuing a notice of federal tax lien to dispute the lien, or you can request the collection due process hearing if the IRS issues a final notice of intent to levy. So before they can actually levy your bank account or your wages or any other property, except for very rare circumstances, which we won't be discussing today, they have to give you an opportunity to request a collection due process hearing. Now, collection due process hearing gives you a couple of different options. The first is it gives you the option to propose a collection alternative to either the tax lien or the tax levy. If the IRS proposes a levy, you can say, well, no, I either want to submit an offer in compromise, or I want to propose an installment agreement or not collectible status, whatever the case may be. Generally speaking, you cannot dispute the underlying liability in a collection due process hearing unless you have not received a prior opportunity to do so, either through an IRS notice of deficiency or through an appeal of an assessment, for example, for a trust fund recovery penalty assessment or certain employment tax assessments, things of that nature, where you will not be receiving a notice of deficiency. Only in less common circumstances can you actually dispute the liability in the collection due process hearing, unless the IRS sometimes messes up procedurally and not send you a notice of deficiency, circumstances such as that as well. So for example, let's say you owe the IRS $100,000, your case gets assigned to an IRS revenue officer, and you're working with the revenue officer and you say, I want to pay an installment agreement of $500 a month, and the IRS revenue officer tells you, no, we believe you can pay $10,000 a month to pay off this liability. If you're in disagreement, that IRS revenue officer at some point is going to want to take some collection action if the disagreement cannot be resolved. But once again, they'll have to issue either a federal notice of tax lien or a final notice of intent to levy before they can take that collection action. Now, you only have 30 days from the issuance of that notice to file your request for a collection due process hearing, and always make sure you file the actual hearing and you mail it in via certified mail so that you have proof that you mailed it in timely. If you missed the cutoff date, you're still eligible for what is called an equivalent hearing. That can be filed within 1 year, but it does not prevent the IRS's collection action on the case. As an administrative matter, in a lot of instances, the IRS does not take collection action while waiting for the equivalent hearing, but best not to take that chance. Definitely make sure you file that request for collection due process hearing within 30 days of the IRS issuing the final notice of intent to levy or the notice of federal tax lien. Once you file your request for collection due process hearing, your case will be assigned to an IRS Appeals Officer. And that Appeals Officer We'll review your case, review your collection alternatives that you're proposing, or other issues that you bring up during the request for a collection due process hearing. If the appeals officer agrees with your proposed alternative, then they will resolve the case, and that will be the end of the matter. If the IRS does not agree with your collection alternative, they will issue a notice of determination. That notice of determination will issue, usually kind of give a brief synopsis of the case, why the IRS is still disagreement, and then that'll give you a 30-day time window to file a petition with the United States Tax Court if you are in disagreement. So that's a little bit about IRS collection due process hearings. Make sure you do not miss this amazing weapon at your disposal if you're ever in trouble with the IRS. If you have any questions on any collection matters, feel free to visit our website or give us a call. Make sure to subscribe to our page for weekly updates on IRS collection issues. Thank you.